Call the list. Item number 1 and 2.
May it please you, Lordships. My lord, I had yesterday stopped after showing, my lord, the initial affidavit that was filed by the petitioners pursuant to the direction of the court to show as to what was the prejudice this was suffering. My lord, that I have shown your lordship in some detail. Now, my lord, so far as this is concerned, my lord, here, my lord, I have also shown to your lordship that we have identified each of my lord aspects on which I had deliberated while showing your lordship the notifications by which the amendments were effected. Well, that is, my lord, with regard to the pricing, the storage, the acquisition, etc. Well, all these were individually highlighted, my lord, in the affidavit that we had filed. So, my lord, I will not trouble your lordships any further with that. Now, my lord, state filed, my lord, an initial response, which is also largely repeated by them in their subsequent response. I'll show you lordships how they have dealt with it. My lord, this is an affidavit filed by the state on 27 September 2021. This was the first affidavit filed by the state in the proceeding.
Just this is from my lords. Then it is better place.
May I request your lordships to please have a look at paragraph 2 of the affidavit, under the heading preliminary submissions. Well, here the state makes a concession. It says that, my lord, validity of a subordinate legislation can be challenged only on 3 grounds. One is legislative competence, 2 is ultra vires the parent enactment, and 3 is violation of any fundamental right. Now, my lord, my submission before your lordship is that, my lord, this is ultra vires the parent enactment, violative of, my lord, the fundamental rights of the petitioner. Both under Articles 19 and Article 14. Now, if your lordships will next have a look at, my lord, how the state proceeds to deal with, my lord, the different provisions. Well, at paragraph 15, which is at page 8 of the affidavit, well, the state makes a reference to the rulemaking power under section 36 of the Meghalaya Excise Act. Well, I shall deal with that. Then, my lords, will kindly have a look at, my lord, paragraph 18, which is at page 9. Now, my lord, this is very important. My lord, this is a part of, my lord, the Meghalaya Excise Act, my lord, which would put the rulemaking power so far as, my lord, granting exclusivity is concerned in the matter of distribution of liquor, well, with very narrow confines. Please have a look at, my lord, section 19, which is quoted in paragraph 18. The state government may grant to any person on conditions and for such period as it may think fit the exclusive privilege of manufacturing or of supplying to the licensed vendor. Remember, these are very important words. Any country liquor or intoxicating drugs within any specified local area. Now, the important words are that exclusive privilege under the statute can be granted only for the manufacturing or supplying to licensed vendors any country liquor or any intoxicating drug. So, this is confined to country liquor or intoxicating drug. It will not extend to Indian-made foreign liquor. And so far as this is concerned, the other part is, which is important, is this exclusive privilege of manufacture or of supply. Kindly note the word or here. Whether it is either manufacture or supply, and supply would include the distribution channels, is ultimately confined to any specified local area, not the entire state. So, if today the section or the statute clearly says that your right to grant exclusive privilege is confined only to A, country liquor, B, to intoxicating drugs, which are both defined under the Excise Act, and it is to be ultimately granted for a specified local area, kindly mark the word specified local area, then three things: it can't be ultimately applied to Indian-made foreign liquor, and it can't be granted for the entire state of Meghalaya. And your lordships have seen that so far as this is concerned, it has now been granted for the entire state of Meghalaya. Now the answer is, if your lordship sees the discussion, because this is our point of challenge. If your lordship sees paragraph 19, this is how they deal with section 19. Says that it is submitted that the said contention of the petition is erroneous, inasmuch as firstly section 19 pertains to manufacture and supply of liquor and does not relate to import of intoxicants in the state of Meghalaya, which is governed by chapter 3 of the Meghalaya Excise Act and is governed by sections 12, 13 and 14 of the Meghalaya Excise Act. It is stated that section 19 is contained in chapter 4, which relates to manufacture, sale and possession.
But this country liquor does not include foreign liquor.
No. Clearly does not include. Well, I should show you lots of the definitions from that. I am just showing what the stand of the state is. It first says it is exercising its rulemaking powers within the confines of under section 36. Now, section 36 says in accordance with the statute. If section 19 of the statute says that you can only make this power or grant this exclusive power in respect of country liquor or intoxicating drugs, both of which are defined, and you cannot ultimately extend it in case of anything else, and also that you must confine it to a specified local area, then the question is, how do you extend this privilege in case of IMFL and for the entire state? That becomes a question. And in dealing with that, the only answer is that, look here, so far as the Act is concerned, sections 12, 13 and 14 deal with import of intoxicants in the state, and section 19 falls under chapter 4, which relates to manufacture and sale. So therefore it does not apply. Now, I have not been able to appreciate this argument at all, because ultimately when we use the word manufacture or supply, the question is whether supply within the state would include supply through the bonded warehouses. In any case,
but here supply refers to only country liquor.
That's it. And here the exclusivity is sought to be granted in respect of supply of IMFL. But my learned friends say that supply will not be covered, because import of intoxicants in the state is governed by part 3. And this part 4, section 19, which is a part of part 4, deals with manufacture and supply, manufacture and sale. Now, the question is, kindly see the words manufacture, then the disjunctive or, and the use of the expression sale, or supply. Supply, is supply to all the retailers through the route of the bonded warehouses, and ultimately through the acquisition of the foreign liquor by the CBW. But exclusivity at the end of the day must be confined to country liquor, number one. Number two, in respect of intoxicating drugs, and must be for a specified local area. Can't be for the entire state. And that could be on the government or the state perceiving the need to grant exclusivity for a particular public purpose to a specified local area. That is not expressed anywhere. So, the first part of the argument, is that section 19 does not apply only because it forms a part of chapter 4 or part 4 of the statute and not otherwise. Then, my lords, will kindly see, my lord, the next, my lord, paragraph in the same affidavit, page 10. My lord, then, my lord, the argument is, trade in liquor is res extra commercium. No fundamental right or legal right to trade in liquor. That is the next argument. Now, my lord, res extra commercium, my lord, as we understand, applies to, my lord, something that is inherently pernicious. But although, my lord, we have used the expression res extra commercium, my lord, a little liberally. My lord, ultimately, my lord, if today you cannot trade in a particular item at all, then it's res extra commercium. Now, my lord, our courts have held that so far as this is concerned, the right to trade in liquor is a right that is available. If you have a right to, my lord, one of the judgments that I shall be showing to your lordship says, if you have a right to sell ghee, and that is not ultimately prohibited, then you have a right to sell liquor as well. Of course, there are regulations. And these regulations are reasonable restrictions under Article 19. And, my lord, they are abided by. But it is not as if it's really res extra commercium in the sense that no one can deal with it. Now, the decisions say...
When this foreign liquor, please clarify this point, when the foreign liquor is sold in the market by the ultimate retailer,
Yes.
who puts the price tag? The retailer, or is it the manufacturer who puts the price tag and sends it to the retailer?
The price tag is put by the bonder, by the state. The state fixes the bond price. Now, the bond price used to previously include the price paid to the bottler, distiller, or manufacturer. Then, my lord, would include the cost of freight, my lord, the bonded warehouse commission, and then thereafter there would be added, my lord, as per the directives of the state, my lord, the relevant duties, excise duty and other duties that are payable. Finally, my lord, the retailer's commission, my lord, which is the, my lord, maximum selling price. That is what the consumer would pay.
So that is put as a sticker on the bottle.
That's right. That's right. Now, well, let us say that ultimately the sticker price is 100 rupees. Well, post 100 rupees. Now, this can be divided into two parts. One is up to, my lord, leaving the bonded warehouse go down. And, my lord, before leaving the bonded warehouse go down. So, my lord, before it comes to the bonded warehouse or leaves, the expression should be before it leaves the bonded warehouse, my lord, which includes, my lord, A, the price paid to the distiller, bottler, manufacturer, my lord, the freight and, my lord, warehousing charges. Then, my lord, it includes the bonded warehouse commission. And, my lord, the relevant duties that are leviable on the product. And thereafter, my lord, we have the second set. My lord, this is now, my lord, the price at which the retailer, my lord, takes the goods, puts a markup on that good, which is permitted. And then, my lord, we have the MRP, which is the maximum retail price at which the consumer buys it.
So the amount that is paid to the distiller is one part, then freight and warehouse charge.
That's right. Now, my lord, the bond price, my lord, is fixed by the state government at the first
Then
stage.
the commission.
Yes. So the bond price includes the price paid to the distiller, bottler, manufacturer, the freight, warehousing charges and administrative charges, the bonded warehouse commission, and the taxes and duties.
That is the bond price.
That's right.
My lord, sorry, not to interrupt my learned friend. At page 32 of the, I'm sure he has at the center, the central bonded affidavit, they've given a cost chart. Your lordship will get all the ingredients in the cost chart. If your lordship is interested in all the various.
So I should take your lordship to that.
If your lordship is interested in that breakup, that is where my learned friend can show it. Yeah.
Well, this is the breakup given by the CBW.
Yeah.
But I should take your lordship to what the CBW has to say later.
And then after it leaves the bonded warehouse,
Well, after that, my lord, naturally, the retailer, my lord, marks up the goods with his own commission, the retail price, retail commission. And then, my lord, the retail price is, my lord, affixed to the bottle, which is the maximum retail price, which is allowed by the state. And the consumer pays that. Now, my lord, here, the question is, my lord, if the bond price is fixed by the state, and previously the bond price would accommodate within its scope, but only, my lord, the administrative charges, warehousing charges, freight, and the bonder's commission, then the question is, now with the imposition of the CBW, this is increased manifold. Now the object was to increase it manifold. I've shown your lordship the letter written by the CBW yesterday.
Yes.
Now my learned friends have now come on record with an affidavit which I shall show your lordship, which says, or an application which says that we have not charged this commission. They have not charged this commission during the pendency of the writ petition. They have not said, or there is no declaration by the CBW that they will never charge this commission. But the margin is the least important of all things.
So now by this notification, the bounded warehouses commission has been raised to how much from?
They had initially circulated a letter, which I had shown your lordship yesterday, by which they proposed to impose a margin of 25%, which would include the bonded warehouse commission of 8%, therefore leaving 17% for the CBW, Central Bonded Warehouse. And that, as I told your lordships yesterday, would have to be absorbed either by the distiller bottler manufacturer, so it will come out of its profits, or it would be ultimately passed on to the ultimate consumer, which would raise the cost of the product significantly, and therefore would reflect on the demand for the product.
So previously it was only 8%.
8% bonded warehouse commission. Ex bond price, yes.
Yes.
Now, my challenge was threefold. In the petition, on the basis of what I have pointed out to your lordship, A is, it creates a monopoly, which is not permitted.
Yes.
B is that, it is ultra-violated the statute. I have shown your lordship section 19. And C is it's violative. It violates fundamental rights, including most importantly Article 14, because it gives untrammeled and unregulated powers. And it distorts the level playing field which existed and which allowed the market to determine as to how the trade would proceed in the sale of particular brands. Now, I'm very briefly showing your lordship now what is the state's response. Before I go to show your lordship as to why I must succeed in my challenge. Now, I have shown your lordship how they have proceeded to deal with my first argument. That is the argument of statutory ultra-vires. That it is not ultimately governed by section 19. So what the state really says is, yes, it would be all right. There would be a fetter, there would be a restriction confining the grant of exclusive privilege only to country liquor and intoxicating drugs and within specified local area. But section 19 does not apply, because the provision that governs importation of intoxicants into the state is the chapter 3 or part 3 of the statute, and this is a part of part 4. So, it is really confession and avoidance in a sense. There's yes, it would apply, but because it is not sale and manufacture per se, it will not be the provision that will ultimately be applicable. But what about the avowed objective of the statute, which says that ultimately it is to be confined to intoxicating drugs and country liquor within a specified local area? There is no explanation for that. There is no attempt to touch upon that at all. And now when my learned friends rely on regulation, on rule section 36, which is the rule-making power, the rule-making power, I should show you lordships, ultimately says to give legs or teeth to the object of the statute. It can't go beyond the object of the statute or beyond the confines of the statute. The second objection is what your lordship finds in head note B, which is at page 10 of the affidavit. Here they deal with the objection with regard to monopolistic practice, creation of a monopoly. Now, so far as that is concerned, their argument is trade in liquor is res extra commercium, no fundamental right or legal right to trade in liquor. Now, to that my answer is very clear. The decisions rendered over the last few decades are very clear that the state may ultimately prohibit.
Right. The state has legislated to facilitate this trade.
Yes, but the Constitution
The
says,
state cannot turn around and say that it is a kind of an
That's
illegal
right.
trade, yes.
and my lord, the law is very clear. It says the state can create a monopoly if, my lord, it is the state monopoly or, my lord, monopoly which is ultimately allowed through a state-owned corporation, not, my lord, through individuals.
Like if the state permits horse racing, it cannot turn around and say it is wagered.
That's right. My lord, that is a second point. My lord, then, my lord, they refer to, my lord, a few judgments and, my lord, Article 47, which is the directive principles of state policy, to say that, my lord, there should be a prohibition of intoxicating drinks and drugs, my lord, which really means nothing because, my lord, there is no prohibition imposed. Only object is to regulate. I would have understood, my lord, like in some state of Gujarat, there is prohibition. My lord, that, my lord, is something that the government has decided in its best, my lord, wisdom to impose, but not, my lord, in states which has permitted the sale of liquor. Then please see, my lord, page 13. I'll just show you lots of the head notes so that I can quickly cover it. Well, it says, my lord, at Roman 2, at page 13, amendment rules of establishing CWD is a policy decision in public interest and beyond judicial review. Now, my lord, I am trying to find out the public interest involved. Well, today, the public interest must, my lord, be something that is either professed or, my lord, something that clearly appears from the legislation or the amending legislation itself. Now, my lord, when I say that, my lord, you are creating a third entity to carry out the same activities which were being carried out by 45 bonded warehouses earlier, without any value addition to the services, without seeking to regulate the service in any manner, there is no explanation for that. When I say that this ultimately distorts the route to market, it's a third entity which is going to increase the cost of the product without any additional service being provided, no answer to that. When I say that this ultimately has the risk or potential of securing the level playing field by regulating the commissions or the margins, by regulating the stocking of the product, by regulating the credit policy which will be ultimately awarded to the different bonded warehouses, there is no answer to that. The only, my lord, very generic answer is that it's a matter of policy. Now, my lord, in an attempt to justify, as to, my lord, why this is brought about, your lordship will see, my lord, the subheadings under this Roman 2, my lord, which your lordship will find at paragraph 27, A, B, C, etc. Now, this is what they say. And this is not what the bonded warehouses say, because, my lord, the bonded warehouses, as your lordships have been told, have filed an independent writ petition through their association. Please see, my lord, clause A, page 14. Benefit to small bonded warehouses. My lord, not supported by any empirical data, just a, my lord, statement made for the purpose of defending this, my lord, so-called policy decision, which ultimately does not reflect of any policy which would subserve any public purpose. Please see, my lord, page 2014, A. Benefit to small bonded warehouses. That it is submitted that with the introduction of central bonded warehouse, any bonded warehouse will be able to indent any brand as per their specific requirement, which in turn would result in minimizing their investment with assured turnover, since central bonded warehouse would be able to supply an assorted range of products in a single truck, which otherwise had to be procured truck-wise from different companies' locations. Now, this statement is made without any empirical data to back it up. And where no data has been forthcoming in the various affidavits which has since been filed. So, my lord, it says it will allow, my lord, any bonded warehouse to be able to indent any brand. Well, there was no fetter earlier. They could earlier also, my lord, indent any brand. Well, it would depend on the customer choice in the region where the bonded warehouse is located. So, well, there is no justification, it is only a statement, and it says would be able to supply an assorted range of products in a single truck, which otherwise had to be procured truck-wise from different companies. I see no reason or basis for this statement. Then, well, please see, ease in tax administration. That it is submitted that with the introduction of CBW, it would be easier for the government to exercise controls and monitor one entity in place of existing 45 and above bonded warehouses, and also it serves as a single point for collection of duties, fees, etc. levied by the government, thus helping in plugging the revenue leakages when in the system. CBW is governed by all the extent by Meghalaya bonded warehouse rules under the supervision and control of Excise Department, right from importing liquor. So it says ease in tax administration. Now there was nothing which is shown to your lordships by way of any empirical data to show that there were leakages in the tax administration earlier. Now if the administration fails to do its duty, then it is not a fault of the system. It is the fault of the officers who have been empowered with the job of administering the system. Now here, just to amplify this point, my learned friends have now filed an application, which is the last application for which Mr. Banerjee sought leave yesterday. And this is what the application has tried to highlight. They have relied on a Controller Auditor General report, a CAG report for the year ended 31st March 2018. Now, 31st March 2018 is the year, and this policy came into effect in the year 2021, intended to take effect from 15th October 2020, but thereafter, ultimately, 2021 is when it really became effective with the invitation of tenders, etc. Now, I'll just show you, Lordship, this immediately. Just show you, Lordship, this is what it says. I'll take your Lordship through this application later, but in the CAG report, which is at page 168 of this application, this is what it says with regard to the State Excise Department. This is the new application filed. 8. Now, this report does not anywhere mention that collection of excise duty is difficult in the hands of 45 bonded warehouses. All that it says in this regard at page 168 is, please see the part which deals with Chapter 3 State Excise Department. It says failure of the department to monitor the bonded warehouse resulted in non-realization of revenue amounting to 3.86 crores. Systemic failure of the excise department in monitoring the activities of the bonded warehouses resulted in evasion of excise duty amounting to 1.86 crores. This does not say that there is difficulty in administering 45 bonded warehouses or making tax collection. It only says in a report which is now disclosed in the year 2025, along with this application, not pointing out that there are faults in the system which makes it possible to avoid excise duty. If ultimately excise duty is collected through the separate bonded warehouses, it only says failure of the department to monitor the bonded warehouse. And systemic failure of the excise department in monitoring the activities. But in any case, this would not be justification for permitting a monopoly. The monopoly is not allowed in the hands of an individual or an individual entity. So here, this is how it proceeds to deal with aspect of policy decision, which your lordships have seen. The first, they said benefit to small bonded warehouses, and then it says ease in tax administration, and then please see at page 15 wider range of brands. Again, it really defies logic. Well, all the brands were previously available, all the brands are also presently available. In the creation of CBW, that the creation of CBW is to facilitate availability of a wider range of brands to the consumer of the state, as per their likes and preferences, and to enable the bonded warehouses with lesser financial capability to compete with big players on the level playing field. admitted that the CBW, due to economics of scale, would be in a better position to cater to the demands or intents of the bonded warehouses in the state, irrespective of the location. Onus of transportation and delivery of goods to the bonded warehouses across the state is again on CBW, and the investment on account of payment of prepaid ad valorem duty, in addition to the cost price of liquor, rests on CBW. My lord, it can't be said that, my lord, they are going to allow the bonded warehouses to lift, my lord, the products without paying the consequential excise duty to the CBW. Or, my lord, the economics of scale that there has been no complaint by any, my lord, of the bonded warehouses at any prior point of time saying that, look, we are being prevented from really carrying on a business or making available the brands or the wider range of brands to our customers. And the last point of justification, well, here, of course, no, not the last, second last, is kindly see increase in revenue due to license fees. CBW in place, that with CBW in place, the revenue stream to the government would in no way be compromised. Rather, by the levying license fee, government tends to gain, and not only that, monitoring a single entity would any day, any time be easier for the government to check. So, what they're saying is that we are going to charge a license fee from the CBW, so we are going to make money. But at what cost? You charge a license fee of 1.5 crores, that is, the license fee indicated in the tender. Well, ultimately, you do what? The CBW commission that you allow the CBW to earn without performing any extra or additional or different function is, something that is enormously going to adversely affect the pricing of the sale of liquor in the state, or adversely affect the pricing in the hands of the bottler, manufacturer or distiller. And finally, if your lordship sees benefit to suppliers or manufacturers, page 16. Suppliers would also benefit from the introduction of CBW, as the same would lead to overall increase in consumer demand. I don't understand, how are these statements made? One can simply sit in a chamber and dream up these statements by way of defense to an action such as this. I would have appreciated the availability of empirical data to make the statement. Now, none of these statements are backed up by any data. Now, so far as this is concerned, here, if your lordships will see, then it says at paragraph Roman 3, impugned notifications, that's at page 16, do not create monopoly in favor of the respondent number 3. Now, what is the justification? Here at paragraph 39, your lordship will find reliance placed on a judgment in the case of Kuvarji Bharucha. This is a 5-judge bench of the Supreme Court. This was explained by another 5-judge bench, in Narula, which I should show you lordships. And reference is made to association registration of plates, which is is quite one of a kind judgment, because it dealt with a situation where a specialized item was being sought to be manufactured. And that is really the argument. I should just show you lordship the headings, and then I should deal with them. Then if your lordships will see the next heading of defense, that's at page 21. Page 21, it says, impugned rules provide for requisite checks and balances and does not accord untrammeled power. Now, I have highlighted the concerns that flow from these notifications which are now under challenge. Please, see as to how, they have dealt with the question of, A, pricing, B, margins, C, stocking, D, making available, the products to, the consumers, B, the concerns with regard to, granting special, benefits to, some of the players who are both, upstream, downstream players, etc. Now, please see, these, provisions under paragraph 41, 42. Says, firstly, several members of the petition association have already started to supply liquor. That is not a ground to say that this does not ultimately waste untrammeled power. Secondly, that's paragraph 43. Not the case that the functioning of the CBW is by way of any unchecked powers. The rules stipulate plenty of checks and balances. Now, when I've highlighted what are the concerns as to why the checks and balances are not available, not answered. Then, my lord, kindly see 43A. CBW is required to procure all types of liquor. All types of liquor, but no, my lord, provision with regard to what is the minimum stock, how the minimum stock is to be determined, what is the period within which the stock must be supplied. They say 60-day period, and my lord, they also say for immediate, continuous, regular supply, which I pointed out to your lordships yesterday, which are at cross purposes. Then, my lord, we'll have a look at, my lord, the various definitions that they rely on. Then page 24. My lord, paragraph B, thirdly, CBW is required to maintain a minimum reserve of liquor. My lord, we have, my lord, made our comments on minimum stocks. How, my lord, minimum stock is to be determined? Who will determine it? If there is a dispute with regard to minimum stock, how will it be resolved? Nothing answered. Fourthly, my lord, that's paragraph C at page 24. CBW is also required to maintain minimum stocks of each brand. My lord, the answer is the same. No answer, my lord, to the concerns that we have raised or flagged. Fifthly, my lord, that's again at page 24. Even otherwise, so far as maintenance of minimum stock is concerned, all Meghalaya Bonded Warehouse Association and East Khasi Hills Wine Dealers and Dealer Welfare Association has submitted a representation where they have requested government to ensure Central Bonded Warehouse supplies fresh stock of liquor. But I don't know, my lord, how this, my lord, goes to address the concerns of unchecked powers that have been, my lord, bestowed on the CBW. Sixthly, page 25. Clause E or paragraph E. Sixthly, even otherwise, so far as maintenance of minimum stock is concerned, even prior to the introduction of CBW, also the bonded warehouses were assessing the demand in the market, accordingly determining the minimum stock to be procured. Then seventhly, paragraph F. It says, it is not correct that the CBW licensee would have untrammeled powers to dictate the availability of products, inasmuch it is the bonded warehouse which will be placing the demand of stock, and CBW is bound to provide the same within 45 to 60 days. Well, I have shown your lordship that, well, there is no basis for ascertaining the minimum stock. And if today the bonded warehouse comes and says, give me goods, and he says, I don't have this particular brand available, take something else, then that's the end of the matter. Says regular continuous supply, but says wait for 60 days. Well, no one will wait for 60 days. Then, my lord, kindly see, my lord, eighthly, paragraph G. Even on matters of pricing, there is no uncanalized power conferred by the CBW. Well, I have shown that, my lord, there is no definition of, my lord, how the CBW's margin is to be fixed. How, my lord, the credit periods are to be determined. How, my lord, the pricing of the goods are ultimately to be affected, taking into account the CBW commission, which, my lord, now comes out of the blue, without any function, additional function, power, or, my lord, service. Ninthly, there is also no question of promoting one brand over the other. Preference is not permissible nor possible. Well, I have shown that how, my lord, this might be misused, the powers, in, my lord, promoting one brand over the other. Tenthly, even the contention of the petition as per 36(4) of the Meghalaya Act, there is no bar on monopoly. Well, this is how they deal with the various apprehensions we have expressed, really basically, well, it's saying nothing, merely saying that no, there is no monopoly, there is no untrammeled power, there is no minimum stocks will be maintained, there is no preference to be given. So, my lord, general, my lord, pious platitudes expressed without, my lord, really addressing the concerns that we have raised. They have not said, for example, my lord, how, my lord, minimum stocks will be determined. They have not said, for example, as to how, my lord, who will determine the minimum stocks or the basis for determination. They have not said how, my lord, in the event of any dispute, this question will be addressed. They have not said as to, my lord, how, my lord, the stocking will be of all brands for a period of 30 to 60 days to allow a bonded warehouse to immediately avail of products. Because, my lord, kindly see, on the one hand, it says that you must maintain 3 months stock. On the other hand, it says that you have to place indent 60 days before or 90 days before, and then you will get delivery of the goods. Well, nothing matches up. Well, there is no sync of one provision with the other. What I am trying to, my lord, assert before your lordships is, my lord, in the course of, my lord, their affidavit, there is no attempt to, my lord, explain that no, look, your concern is with regard to the margin. This is the margin. Your concern is with regard to the service. This is the extra or additional service. Your concern is with regard to the purpose. The bonded hub warehouses are serving the purpose. We are also going to serve this additional purpose. There is no, my lord, explanation with regard to concern as to, my lord, how the minimum stocks. My lord, nothing is dealt with. Yet they say that no, everything is there, taken care of. There are no untrammeled powers, though no uncanalist power, etc., etc., etc. My lord, this is the basis of the defense. Now, my lord, here, my lord, just to drive home the point, I have shown your lordship, my lord, section 19. Well, I'll take the 3 points and, my lord, argue them and, my lord, try to conclude. My lord, point number 1, let us start with, my lord, the question of statutory ultra-vires. Your lordship has seen, my lord, section 19. Your lordship has seen, my lord, how it is confined to only, my lord, country liquor and intoxicating drugs. And, my lord, how it must be, my lord, in a specified local area. Now, my lord, when we raise this point, my lord, there is no assertions. My lord, this is, my lord, my argument on, my lord, each of my 3 points that I shall be asserting before your lordships. Point number 1, my lord, the statute clearly provides in section 19 that the power to grant exclusive privilege will be confined only to country liquor or intoxicating drug and must be confined to a specified local area. Now, my lord, so far as that is concerned, it is not my learned friend's contention that, my lord, country liquor and IMFL is the same. They don't say that. They accept the fact that Indian-made foreign liquor and country liquor are 2 different, my lord, commodities altogether. So, my lord, this is an admission that, my lord, country liquor and IMFL is not the same. Secondly, my lord, so far as this is concerned, my lord, there is an attempt now to say, notwithstanding the fact that country liquor and IMFL are not the same, to say that all liquor is a part of intoxicating drugs, and hence, my lord, IMFL is also an intoxicating drug. My lord, when intoxicating drug has been separately defined. Now, my lord, for this, I will request your lordship to kindly have a look at the statute once, and, my lord, its definitions. My lord, your lordship will kindly have a look at the Excise Act. I believe your lordships have a copy, my lord. On the last occasion, I had shown your lordships the copy of the statute.
Section direction?
Definition section. My lord, may I request your lordships to please have a look at, my lord, the definition section, my lord, which is section 3. Lord, may I request your lordships to, my lord, please have a look at, my lord, 3 subsection 13, which defines intoxicating drugs. Now, this should be in at page 9 of the statute. Well, at 3 subsection 13, intoxicating drugs at page, it should be page 9. Page 9.
Yes.
Well, please see the definition. Intoxicating drugs means 1. The leaves, small stalks and flowering or fruiting tops of Indian hemp plant, cannabis sativa, including all forms known as bhang, siddhi or ganja. Then, my lord, we'll kindly have a look at, my lord, subsection 4. Then, my lord, there's charas and, my lord, other mixtures, etc. Then, subsection 14, liquor. Liquor means intoxicating liquor and includes all liquid consisting of or containing alcohol, and also tari and pachwa, etc. in any form. Now, my lord, so far as liquor is concerned, your lordship will please see, my lord, there are 2 kinds of liquor that are, my lord, contemplated under the statute that your lordship will find at paragraph 4, section 4. Section 4, my lord, is your lordship will find is at page 17. Powers to define country liquor and foreign liquor respectively. State government may by notification declare what for the purpose of this act shall be deemed to be country liquor and foreign liquor. Now, my lord, they have identified country liquor in section 19. No reference is made to foreign liquor whatsoever. And my lord, so far as this is concerned, now please have a look at, my lord, the provision. My lord, kindly, my lords will kindly come back to my lord the objection. Now, my lord, they say that therefore, my lord, ultimately they say that so far as liquor is concerned, liquor being an intoxicating drug, which is, my lord, not under the definition of intoxicating drug at all, my lord, it ultimately falls within the domain of exclusive privilege. My lord, which is not the case because, my lord, ultimately the expression used very consciously is country liquor. And the expression used very consciously is intoxicating drug. Well, IMFL is neither country liquor nor intoxicating drug.
Just to save some element of my learned friend's time, I am not arguing this, what my learned friend is saying. He need not trouble himself by this particular argument because that's not the argument I'm making.
Well, that is, my lord, what the state has argued.
Legal submissions are not confined to counsel on the basis of affidavits. No. Again, my interpretation of the section 19 will be my interpretation, which I play before my lord. I'm merely pointing out for my lord friend's assistance that if you think this is an argument, he will not deal with this.
No, very well, my lord. What I tried to point out, and
I should be fair. This is possibly my learned friend is right, and therefore I'm not saying anything more on this. He need not trouble himself much on this particular argument.
Always easier to have, my lord, Mr. Banerjee, but his fairness, my lord, ultimately transcends many things. My lord, so far as, my lord, therefore, my lord, coming back to, my lord, section 19, the question of statutory authorised. The next point, my lord, that is urged is, my lord, part 3 and part 4 of the statute. Now, my lord, if your lordship will kindly have a look at, my lord, part 3 of the statute, my lord, which is, my lord, again an argument. My lord, here your lordships will find, my lord, part 3 of the statute, or the chapter 3 of the statute starts at page 20.
Just trying to put it the way I have understood it, so that your arguments will be, you will be able to make further arguments and I will be able to appreciate your.
Yes, madam, of course.
That first, the foreign manufacturer or the Indian manufacturer is not allowed to sell his product directly. Number 2, previously, he was to sell it through a chain of bonded warehouses, which say, let us put the nomenclature through agents.
Right.
Now by this, the agent earning X commission, which is 8%. Now by this notification, number 1, it does not have any recital that why this notification is being made to justify. It is just a bare order notification of the government in exercise of power under section 36. It says that on top of that agent, an agent is that CWC is kind of appointed by legislation or subordinate legislation, whereby these bonded warehouses get the status or assume the status of sub-agents.
Right.
And which, amongst other things, according to your argument, result in escalation of cost, the ultimate cost which the buyer of the bottle has to pay.
Escalation of cost and, my lord, the apprehension of, my lord, ultimately conferring, my lord, benefits to, my lord, one over the other by, my lord, regulating stocks, regulating supplies.
Now, in terms of constitutional violation or statutory violation, how this legislation, it is without any recital at all, but why it is being made.
That's right.
So, in what way it can be ex facie attacked that it is violative of the constitution, or one is Article 19, no doubt.
But I just summarize it, my lord. The law says very clearly, well, A, you can't create a monopoly. Now, my lord, what has been created is a monopoly in the hands of a particular entity, because that is now the sole or singular point of import of the goods into the state, and the singular point of distribution of the goods, my lord, to the bonded manufacturers and through them to the retailers. So, my lord, the monopoly is created. It is not a state monopoly. It is not monopoly by a state corporation.
So the bonded warehouses can no longer get it directly from the manufacturer or distiller. They have to get it from the CWC.
And when the CWC then can, my lord, ultimately control, my lord, the supply, the stocking, the availability of the products, etc. My lord, which we have identified in our first affidavit. Now, that is the first point. So, my lord, creation of monopoly barred by Article 19 does not, my lord, conform to the, my lord, reasonable restriction clause in Article 19.6. And, my lord, Article 19.6 allows a monopoly only in the hands of the state or state corporation. This is neither a state nor a state corporation. And, my lord, I have also precised this with, my lord, a submission yesterday, saying that, my lord, here the CBW, which was allowed ultimately to be established through this, my lord, purported tender process, my lord, is an entity which was set up 1 month before the regulations were amended, and, my lord, tender was floated 1 month thereafter. So, my lord, it was all, my lord, well thought out and in anticipation. And, my lord, these CBW players are both, my lord, owners of bonded warehouses and, my lord, distilling or bottling plants in the state itself. My lord, that is, my lord, the first part. Second part is, my lord, here, my lord, let us say that you have, my lord, a power to make rules. The rule-making power must ultimately, my lord, being a subordinate legislation, conform to the plenary legislation. It cannot go beyond or exceed the plenary legislation, which is to say that, my lord, you cannot, when Section 19 says that there's a fetter imposed on, my lord, granting exclusive privilege, you cannot seek to overwhelm the statute by now, my lord, through a device of subordinate legislation granting an exclusive privilege which is contrary to the statutory mandate. That is the second argument. The third argument is, my lord, apart from the fact that it's monopoly, my lord, there are, my lord, unchecked powers, my lord, which I have, my lord, tried to highlight in the course of my submissions, my lord, which has the potential of disturbing the route to market, the level playing field, and, my lord, also create, my lord, a class which is a separate class amongst equals, because all the bonded warehouses are performing the same function. Here you suddenly elevate one to a position of a superior bonded warehouse, which ultimately controls the supply to all the bonded warehouses and says, you will now direct your indents to me, when all the bonded warehouses were previously directing their indents directly to the suppliers or manufacturers. And, my lord, here, I have, my lord, tried to highlight that, my lord, there are so many, my lord, ifs and buts that creep in, which in the course of, my lord, their answers in their affidavit, they have not addressed at all. My lord, these are the 3 points. Now, my lord, so far as these 3 points are concerned, I have also tried to show your lordship very, my lord, very fundamentally what are their defenses. The defense to the, my lord, Section 19 argument, statutory ultra vires, is that it is Part 3 and not Part 4. Now, my lord, that is why I would request your lordship to please have a look at Part 3. Well, so far as Part 3 of the statute is concerned, that starts from Section 10.
Mr. Shah, consider this argument. Suppose if these intoxicating drugs and country liquor, say, are perceived by the government to be quite dangerous materials, that if allowed to be manufactured and sold freely, it might result in products which might endanger human lives if it is not properly manufactured. So the government has been given the power to identify manufacturers and also identify vendors. That only you can manufacture and only you can vend, so as to protect the manufacture and sale. But this does not in any way affect the foreign liquor market, manufacture or sale.
May I answer your lordship's query? Very pertinent query, but may I answer it, my lord, in my own way. My lord, today regulation is permitted. My lord, regulation has to be, my lord, reasonable restriction or reasonable regulation. Now, I would have still appreciated that says that this is a particular area which is prone to, my lord, the consumption of these intoxicating drugs, so I shall ban this item in this area. Or I shall only sell this item in this area through a permitted regulated vend. My lord, that is not the thing. What they are saying is not, my lord, I want to regulate the use of this substance or the use of this liquor, my lord, so that I have a control over the health, over, my lord, the consequences of consumption of liquor of the people in the area.
No, but consider this, that this does not concern foreign liquor at all. It only concerns country liquor.
That's right.
How it will be manufactured and sold.
That's right.
Upon restriction.
I have no difficulty when I'm accepting Section 19 as it stands.
Yes.
Well, I say that you can't, well, because of the restriction applies under Section 19, well, that is the doctrine of exclusive unions. Well, it says that when the statute says that I prevent something, then it permits the other things to be continued. Well, now the statute imposes a restriction only on country liquor and intoxicating drugs. A. B, very important also. It says even that restriction is to be confined to a specified local area. Now, so far as specified local area, they've made it to the whole state. And they have transited the boundaries of intoxicating drugs and country liquor and said that it will apply to foreign liquor, IMFL. Now, the answer is that Section 19 will have no application. And the answer is Section 19 will have no application because ultimately importation of these liquor into state is governed by Part 3 and not by Part 4, which contains Section 19.
But this, does it exclude the legislation under for foreign liquor?
No.
Section 19?
No.
Subordinate legislation?
No, Section 19 says it will apply, exclusivity will apply to country liquor and intoxicant, not to foreign liquor.
Yes. But that does not bar subordinate legislation in respect of foreign liquor.
No, my lord. Today, my lord, if the statute, my lord, that is the plenary legislation, says
So is it to be implied that since country liquor is restricted, has been made restricted to in terms of manufacturer, vendors, etc.
Yes, my lord, that is, my lord, that is.
But it implies that foreign liquor is made absolutely free in terms of.
My lord, you can't, my lord, impose exclusive. And my lord, kindly also see, my lord, another part of it. My lord, there is no attempt to impose exclusivity because you are allowing 45 bonded warehouses to continue. But my lord, you are imposing a superior authority over them, which ultimately, my lord, renders their individual procuring powers, completely, lost.
Yes. You were sole agents of the foreign manufacturer or Indian manufacturer.
Yes.
Now you become a sub-agent appointed by legislation.
That's right. Now, my lord, here, so far as the question is, my lord, therefore, your lordship's query, if I have understood it correctly, is, my lord, Section 19 when it says that exclusivity is confined to, my lord, country liquor and intoxicating drugs. Well, the first question is, my lord, can it therefore be said that it also implies that it will therefore not apply to anything else? Well, so far as that is concerned, I think, my lord, there can be no doubt because please, my lord, have a look at Section 19 once again. The language is very clear. Well, please have a look at the language of Section 19. Well, that your lordship will find at page 19 of the statute. Or maybe page 31. Page 31 of the statute. Well, this is the power. The state government may grant to any person on such conditions for such period as it may think fit, the exclusive privilege of doing what? Exclusive privilege confined to what? Of manufacturing or of supplying to licensed vendors, or of manufacturing and supplying to licensed vendors any country liquor or intoxicating drug. My lord, kindly see, my lord, first part is exclusive privilege of manufacturing or supplying. Manufacturing is one part, supplying is one part. It may be manufacturing and supplying also. To licensed vendors or manufacturing, supplying to licensed vendors any country liquor or intoxicating drug. So, my lord, if we have to give some meaning to country liquor or intoxicating drug, then, my lord, by natural implication, IMFL will be excluded. And, my lord, also, one has to also say, my lord, this exclusive privilege of manufacture and supply, which is a part of, my lord, Section 19, has to be confined to a specified local area. How can you make it applicable to the entire state? So, my lord, there are two independent separate arguments, my lord, which I make in this regard. And, my lord, this answers the question of, my lord, what is, my lord, statutory ultra vires, how it, my lord, works out, and how it manifests itself. Now, my lord, so far as this is concerned, to answer the question that your lordship has, my lord, put to me, my lord, may I show to your lordship a judgment which I had, my lord, on the previous occasion very briefly placed. My lord, this is the Gram Panchayat case reported in 1989, Supplement Volume 2, Supreme Court Cases, page 465. Well, I just want to draw your lordship's attention to, my lord, the fundamental principle, my lord, which is ultimately the ratio of this decision. That's at paragraph 16. Page paragraph 16.
Paragraph, sorry, I missed.
16. May I just read this one paragraph? I think this sums up what I'm trying to say. Well, this is a well-known and well-accepted principle of interpretation of statutes. The maxim is expressio unius est exclusio ulterius. The paragraph 16. We have already extracted section 42 of the Act and rule 18 of the rules. It would be clear that though section 42 envisaged orders, preparation or confirmation of scheme and repatriation separately, rule 18 provides for limitation only in respect of an application under that section in a proceeding where an order is passed. There is the maxim expressio unius est exclusio ulterius. Expression of one thing is the exclusion of another. Mention of one thing implies the exclusion of another. Where certain persons or things are specified in law, an intention to exclude all others from its operation may be inferred. When mention has been made only of orders, the inference would be that preparation or confirmation of scheme and repatriation are excluded. Then, my lord, the ex precedentibus et consequentibus is, my lord, quoted. The best interpretation is made from the context, as we have seen such and such. My lord, I am not really relying on that. My lord, I am relying on the doctrine where expressio unius est. Expression of one thing is the exclusion of another. Now, my lord, this is not a one-off, my lord, judgment of the Supreme Court. This has been repeatedly, my lord, ultimately adverted to by the Supreme Court and by the High Courts in different matters. My lord, just, my lord, to bring home this argument, may I show you, lordship, another judgment of the Supreme Court. This is reported in 2003, volume 4, Supreme Court cases, page 695.
Yes.
2003, 4 SCC 695. Well, again, just one paragraph. Paragraph 6. Well, this is even more emphatic. Please see paragraph 6. The lessee under the aforesaid terms of lease deed is in fact precluded from using the house for any purpose other than residential purpose. This interpretation would be further supported by the phraseology of the relevant clause such and such, cited above, which contains no reference to the word residential. As a canon of statutory interpretation expressio unius est exclusio ulterius, what is expressly mentioned in one place but not in another must be taken and deliberately omitted. The argument raised by the learned counsel for the appellant proceeds on the assumption that a house by its meaning and definition is capable of being used exclusively for residential purposes and not for non-residential purposes, which is not the correct interpretation. Well, that is how, in my very respectful submission, section 19 has to be read. Because otherwise, there would be no purpose in the statute, saying country liquor and not using the expression liquor, which would subsume within its confines both country liquor and foreign liquor. But the very careful use is of the phraseology country liquor and not foreign liquor. Now, so far as the question is concerned, that how does this therefore ultimately reflect in the amending legislation, which amending legislation has sought to grant exclusivity or exclusive privilege in the matter of IMFL or foreign liquor, and has ultimately extended it, such exclusivity, not to a specified local area but to the entire state. Now, for that, so far as this is concerned, this has, received the, ultimately the question of statutory ultra vires has been decided by the Supreme Court in a number of cases. The earliest perhaps, being the case of Kunja Bihari, or one of the earlier ones. Well, Kunj Bihari, well, this is 2000 volume 3 Supreme Court cases page 40. Well, may I show to your lordships this judgment? Reach.
Thank you.
Well, I do not want to trouble your lordships with what is the subject matter, because I want to straight away get into the proposition. Otherwise, it will take up your lordships' time. 2000 volume 3 Supreme Court cases page 40. Well, a 3-judge bench of the Supreme Court. Well, at paragraphs 8, 13 and 14, your lordship will kindly consider. May I just place these 3 paragraphs? Anil Devan, the learned senior counsel for the appellant, submitted that the lands covered by the 7 categories as defined in clauses A to G of section 5 have been excluded from the applicability of the provisions of the Act. Section 26 delegates to the state government the legislative power of making rules, which delegation is circumscribed by the expression for carrying out the purpose of this Act. Now, let me pause here for a moment and tell your lordship, my lord, section 36 has the similar expression, for the purposes of the Act. In exercise of such delegated power to legislate, the state government cannot bring within the net of the rules what has been excluded by the Act itself. We find merit in the submission so made. Tea estates are excluded from the provisions by the Act by section 5. Tea estate is defined in the interpretation clause of the Act to mean an area under tea plantation and includes within the definition such other area necessary for the purposes subservient to tea plantation as may be prescribed. Rule 3 defines what areas shall be treated as subservient to a tea plantation. The amendment made with a notification dated such and such places an embargo on the operation of the Act. Clearly, the impugned proviso is beyond the rule-making power of the state government as conferred by the Act. It is well settled that the legislature cannot delegate its essential legislative functions, which consist in the determination of choosing of legislative policy and of formally enacting that policy into a binding rule of conduct. What is permitted is the delegation of ancillary or subordinate legislative functions, or what is fictionally called a power to fill up the details. Then, my lords, we'll have a look at paragraphs 13 and 14 at page 258 of the report. It is very common for the legislature to provide for a general rule-making power to carry out the purpose of the Act. When such a power is given, it may be permissible to find out the object of the enactment and then see if the rules framed satisfy the test of having been so framed as to fall within the scope of such general power confirmed. If the rule-making power is not expressed in such a usual general form, then it shall have to be seen if the rules made are protected by the limits prescribed by the Parent Act. From the provisions of the Act, we cannot spell out any legislative intent delegating expressly or by necessary implication the power to enact any prohibition on transfer of land. We are also in agreement with the submission of Sri Devan that by placing complete prohibition on transfer of the land subservient to tea estates, no purpose sought to be achieved by the Act is advanced, and so also such prohibition cannot be sustained. Land forming part of a tea estate, including land subservient to a tea plantation, have been placed beyond the ken of the Act. Such land is not to be taken into account either for calculating the area of surplus land or for calculating the area of land which a person may retain as falling within the ceiling limit. We fail to understand how the restriction on transfer of such land is going to carry out any purpose of the Act. We are fortified in taking such view by the Constitution Bench decision of this court in Bhim Singh Ji, etc., whereby subsection 1 of section 27 of the Urban Land Ceiling and Regulation Act was struck down as invalid so far as it imposed a restriction on transfer of any urban or urbanizable land.
Got it, Mr. Shah?
Yes.
Since your argument is the exclusive and foreign liquor is not covered, so this legislation is also.
And I'll not not my lord multiplied judgment, but this is exactly what has also been said. I should just give your lordship the citations, my lord, just to my lord abridge the time that my lord.
Illegal delegation.
Yes. Now, my lord, this is my lord exactly what has also been said later. I should just give your lordship the citations. In 2000, volume 5 Supreme Court cases, page 451. The relevant paragraphs are paragraphs 14 to 16. And then, my lord, also by the Supreme Court in my lord 2006, volume 4 Supreme Court cases 517.
517.
2006 volume.
Well, the 2006, 2005, 2000 volume 5 Supreme Court cases 451. Then, my lord, 2006 volume 4 Supreme Court cases 517. And, my lord, it's a paragraph number. And, my lord, then, my lord, we have 1988 volume 2 Supreme Court cases 351. But I am not placing these judgments, my lord, because they essentially say the same thing. I shall, however, place one judgment of the Delhi High Court, which sums up the position, my lord, over the years.
1 minute, Mr. Shah. 2000 volume 5 SCC 451.
2000 volume 5 SCC 451. Here the paragraphs are 14 to 16.
Yes. 2006 volume 7 517.
Yes, my lord. But I give you the lordship the paragraph here, my lord. I somehow have missed out noting the paragraph. And then, my lord, 1988 volume 2 Supreme Court cases.
351.
Yes, 351, paragraphs 8 to 14 and 18. Subhash Chandra.
Paragraph 8 to 14.
My lord, yes, my lord, in the other judgment, your lordship may note down it's paragraph 29. That is, my lord, the 2006 judgment.
Paragraph
29. Well, one judgment, however, which I'd like to place is, my lord, the judgment of the Delhi High Court, my lord, authored by, my lord, the present Chief Justice, Justice Sanjeev Khanna. My lord, that, my lord, ultimately deals with the entire, my lord, conspectus of the law on the subject. My lord, may I just hand up, my lord, a copy of that judgment for your lordships? Because this ultimately refers to all the Supreme Court judgments, and, my lord, lays down the law on the basis of that. The citation is, well, 2011 Supreme Court cases online, SCC online Delhi 3033. 2011 SCC online Delhi 3033. Well, paragraph 6 is what I am relying on. Well, because this one ultimately goes on to note the spectrum of judgments on the subject. The rules are subordinate legislation and cannot go beyond the ambit and scope of the main enactment. In additional district magistrate such and such, Delhi, my lord, this is one of the judgments that I have given your lordship.
Paragraph, Mr. Shah.
6. The rules are subordinate legislation and cannot go beyond the ambit and scope of the main enactment. In additional district magistrate revenue, Delhi administration, one of which case I have given your lordship, Supreme Court has observed that the mere conferment of rulemaking power by an act does not mean that the subordinate legislation will go beyond or exceed the scope of the enabling act. It was held, it is well recognized principle of interpretation of a statute that conferment of rulemaking power by an act does not enable the rulemaking authority to make a rule which travels beyond the scope of the enabling act or which is inconsistent therewith or repugnant thereto. From the above discussion, we have no hesitation to hold that by amending the rule and Form P5, the rulemaking authority has exceeded the power conferred on it by the Land Reforms Act. Then, my lord, the next decision is, my lord, Kunj Bihari Lal, my lord, Butail, which I have always placed before your lordship. My lord, that is, my lord, relied on and quoted. I shall not, my lord, read that because I have already, my lord, read it to your lordships. Then, my lord, if your lordship will kindly see, my lord, paragraph 8. My lord, this is the third judgment I have given to your lordships. My lord, this is the 2006, my lord, State of Tamil Nadu judgment. The Supreme Court has held in the state of Tamil Nadu versus P. Krishnamurthy that any subordinate legislation or part thereof which does not conform to the object, scheme and provisions of the parent act under which it is made is invalid. In this case, the court elucidated the grounds on which the subordinate legislation can be challenged. It was observed there is a presumption in favor of constitutionality or validity of a subordinate legislation, and the burden is upon him who attacks it to show that it is invalid. It is also well recognized that a subordinate legislation can be challenged under any of the following grounds: lack of legislative competence, violation of fundamental rights, violation of provision of constitution, failure to conform to the statute under which it is made, which is our case here, repugnancy and manifest arbitrariness, unreasonableness. Now, my lord, this is, my lord, something that I am also, my lord, asserting before lordship. So far as this judgment is concerned, it, my lord, ultimately refers to the Supreme Court judgment in the state of Tamil Nadu and says, my lord, one of the grounds of challenge would be failure to conform to the statute under which it is made or exceeding the limits of authority conferred by the Enabling Act. And, my lord, second, PCF, manifest arbitrariness or unreasonableness to an extent where the court might well say that the legislature never intended to give authority to make such rules. Then paragraph 16, at the next page, the court, considering the validity of a subordinate legislation, will have to consider the nature, object and scheme of the Enabling Act and also the area over which the power has been delegated under the Act, and then decide whether the subordinate legislation conforms to the parent statute. Where a rule is directly inconsistent with the mandatory provision of the statute, then of course, the task of the court is simple and easy. But where the contention is that the inconsistency or non-conformity of the rule is not with reference to any specific provision of the Enabling Act, but with the object and scheme of the parent act, the court should proceed with caution before declaring the Now, my lord, so far as this is concerned, well, if your lordship sees, thereafter, my lord, reference is made to a large number of judgments. Well, I don't want to trouble your lordships with that. What I wanted to show your lordship is, my lord, how the, my lord, judgments of the Supreme Court, which I have, my lord, handed up to your lordships, have been considered. And, my lord, the object is, my lord, the court must, my lord, consider the object and scheme of the Enabling Act. Now, my lord, the object or scheme of the Enabling Act, my lord, is clearly, my lord, to allow, my lord, trade, my lord, through the trade channels established without conferring exclusivity. Because, my lord, that would be, amongst other things, violative of Article 19(6), my lord, which only allows reasonable restriction and further allows, my lord, only state monopoly. Now, my lord, it is not the case that, my lord, we are trying to, my lord, regulate the sale of liquor in the state. That is not their case at all. Their case is that, yes, it can be sold through a large number of vendors, retail vends and bonders, but we are now imposing one person above you all who will have the monopoly in the matter of importing the liquor into the state and distributing it to the different vendors. So, my lord, the object is, my lord, ultimately, if one looks at section 19, confined to, my lord, granting exclusivity, my lord, only in respect of country liquor. My lord, why? Because country liquor, my lord, is not, my lord, perhaps as, my lord, strictly regulated in its manufacture as, my lord, foreign liquors, or intoxicating drugs, which is charas, ganja, bhang, afim, hemp, etc., as defined. So, my lord, there is also, my lord, prescription for, my lord, conferring exclusivity over these, my lord, items and these items alone. And, my lord, one thing which your lordships have seen, the object is not to ultimately, my lord, grant this exclusivity to the entire state. It is to be confined to specified local area. Now, why they have, my lord, not respected at least this mandate of section 19 by confining it to specific local area is also not discussed anywhere by the state in any of its affidavits. So, my lord, if one looks into the object and scheme of the Enabling Act and the area which power has been delegated, the area which power has been delegated is to, my lord, confer exclusivity in the matter of, my lord, country liquor and intoxicating drug, and that too over a specified local area. Then, my lord, one must now look at, my lord, the rule-making power and decipher as to whether the rule-making power intend to overwhelm the statutory limitations which have been ultimately grafted into the statute itself, considering, my lord, the the statutory objective or the statutory scheme.
But where, Mr. Shah, in the rules, in the amended rules, it is mentioned that the central bonded warehouse will get a commission of 25%?
Well, this is mentioned, now, if your lordship will kindly see, it is not mentioned that they will get a commission of 25%. That is, their letter, which I showed to your lordship. Now, which says that, minimum commission paid to the bonded warehouse will be, 8%.
8%.
Now, so far as that is concerned, the central bonded warehouse is, established, as a commercial venture. It, participates in a tender. It, requires a license. It pays a license fee. Now, for that, it is going to earn a revenue. What is the source of revenue? Source of revenue is commission. And so far as the commission is concerned, the commission is not fixed by the statute. Like in the case of bonded warehouse, it says minimum 8%. Here is free for all. And that enabled the bonded warehouse to demand at the initial stages a commission of 25%, which would leave in its hands about 17%. Now, so far as this is concerned, all the time trying to show to your lordship that
where is that demand, Mr. Shah, 25%?
Yes, may I just show your lordship? That your lordship will find, it is at page 11 of the supplementary affidavit that was filed by the petitioner on 14 September 2021. This is a letter written by the Central Bonded Warehouse, Umpoli Central Warehouse, to one of the petitioner's members, Pranod Rikat, at page 11 of the affidavit of 14 September 2021, which is the first supplementary filed by the petitioners pursuant to directions of the court. It says, we suggest that the cost card should be finalized within such and such and should include 25% margin, which includes 8% bond margin, freight, administrative and miscellaneous charges, and CBW margin.
Page 21.
Page 11, my lord. Of the affidavit of 14 September 2021. Please see the third paragraph. This is written by the CBW, Umpulio Central Warehouse, to one of the members of the petitioners. We suggest the cost, page 11.
The affidavit. You are looking at that here. Which? Page 11 is equivalent to paragraph 22.
No, page 11 of the affidavit.
Yes, of the state.
No, not state. Page 11 is the affidavit of the petitioner.
Petitioner.
Filed on the 14th of September.
Okay.
It's annexure B that I was referring to. Please see the third paragraph of this letter. We suggest that the cost card should be finalized within such and such and should include 25% margin, which includes 8% bond margin, freight, administrative and miscellaneous charges, and CBW margin. Now, my lord, two arguments to deal with my case of statutory ultravirus. One is the interpretation of section 19, and the interpretation, my lord, does not say that country liquor or intoxicating drugs are different, my lord, which Mr. Banerjee has very fairly considered is not his argument any longer. And my lord, the second part is that, my lord, it is within the rule-making power. Now, the rule-making power is section 36 of the statute. Please have a look at the statute once again, my lord. Let me show you, lordship, section 36, as to whether, my lord, this gives them the power to, my lord, ultimately overcome the substantive provisions in, my lord, the Enabling Act. So that you, lordship, will find at page 40 of, my lord, the statute.
Section 19.
Section 36.
Yes.
36.
The power of the state government to make rules.
Yes.
Well, please see this. Well, at 36, power of the state government to make rules. The state government may make rules. Now, well, this is exactly what Kunj Bihari Lal also said. For the purpose of carrying out the provisions of this Act, or any other law for the time being in force relating to exercise rules. So, my lord, if today the rule-making power is for the purpose of carrying out the provisions of the Act, and the provisions of the Act, my lord, does not say that confer exclusivity over the entire state, or confer exclusivity over, my lord, IMFL also, then the question is, my lord, whether the rule-making power would permit such provisioning in the subordinate legislation. And well, exactly, my lord, in Kunj Bihari also, you'll also have seen, well, ultimately the reference is to the general rule-making power and says, for the purpose of carrying out the provisions of the Act. And all the judgments that I have cited ultimately have said that ultimately the scheme of the Act, the purpose of the Act, the object of the Act has to be seen. So if the purpose is not to create exclusivity, well, in the hands of, my lord, an individual which is not the state, and also not to create exclusivity beyond, my lord, country liquor and intoxicating drug, or, my lord, in the entire state, my lord, without the confines of a local specified area being pointed out, then, my lord, it is ultravirus the statute. What my learned friends rely on are, my lord, clauses, my lord, 2, D, E, and F, my lord, which can't, my lord, obviously transcend, my lord, section 36, subsection 1, which says, for the purpose of carrying out the provisions of this Act. Now, my lord, what my learned friends say, well, lord, please see 36.1. Well, lord, 36.2D, it says for regulating the import, export, transport, or possession of intoxicant. Now, my lord, there is no regulation. They say that it is only a matter of, my lord, ultimately regulating the collection of excise, etc., etc. There is no regulation that is sought to be imposed. It is not a regulating, my lord, provision. Well, then, my lord, it says regulating the manufacture, supply, storage, or sale of any intoxicant. And regulating the deposit, F is regulating the deposit of intoxicant in warehouses and the removal of such articles from warehouses. Now, my lord, the question is, my lord, first, my lord, with this ultimately, my lord, allow rule-making power, my lord, the general provisioning for the purpose of carrying out the provisions of this Act, my lord, can it be overlooked? And secondly, my lord, today, so far as this is concerned, when the purpose is specified, that, my lord, it must be confined. My lord, then the question is, my lord, to what extent is the confined, my lord, to be read into that? And, my lord, here, Also, my lord, if your lordship sees, well, ultimately, my lord talks about intoxicant. Which, my lord, includes both liquor and intoxicating drug, of course. But, my lord, it ultimately must be intoxicant as considered by the statute. And intoxicant within the meaning of section 19 means intoxicating drug or, my lord, country liquor. Now, my lord, the answer to this has been only twofold. A is the rule-making power allows us to do so. B, manufacture and sale is in part 4, not in part 3. Nothing else.
This will not fall under this. The state government 36(1), the state government may make rules for the purpose of carrying out the provisions of this act or any other law for the time being enforced relating to excise revenue.
Yes, yes, but, my lord, for the purpose of carrying out the provisions of this act, my lord, for the purpose of carrying out this act,
You are saying that the entire notification is dehost the act.
yes, because, my lord, the act that we are talking about, even the excise revenue, is a part of the excise act.
Yes, because under section 19 there is no delegation of power to regulate
That's right.
foreign liquors,
That's right.
manufacture, sale, etc.
That's right. And, my lord, therefore, my lord, first, my lord, we must see for the purpose of the act, and the purpose of the act is, my lord, the purpose to regulate by creating exclusivity only in respect of country liquor, intoxicating drug for specified locality. And, my lord, there is no answer, my lord, as to why, my lord, it must be, therefore, my lord, step out of the confines of this, my lord, country liquor and intoxicating drug and be extended to IMFL. There is no logical answer, there is no purpose expressed, there is no justification given. It's just the ipset of the government, of the state.
How much more time you will take, Mr. Shah?
Well, what I propose to do, well, I know, my lord, your lordship.
Are you here tomorrow or no?
No, my lord. My lord, what I propose to do, my lord, subject to your lordship's, my lord, concurrence, well, I will prepare, my lord, list of, my lord, my notes of arguments.
Mr. Banerjee, are you here tomorrow?
No. But I will argue at some length regarding these judgments and others because
So how much time you are likely to take?
Well, I will, my lord, take, my lord, another 1 hour and I shall finish, my lord, because, my lord, if your lordship permits me another day, I shall finish, but, my lord, what, for your lordship's convenience, what I'll do is, I'll prepare a notes of arguments, my lord, also give it to my learned friend.
very fair, my lord.
So that, my lord, your lordship may, my lord, abridge the time taken. I shouldn't just take your lordship through the, my lord, basics of the arguments and conclude.
When would it be convenient for both of you?
27 and 28, your lordship, March.
March.
Mr. Banerjee, please, we will forget everything.
I have some difficulties, my lord. I have some difficulties.
I was wondering, my lord, if you, since your lordships have heard us at such length now,
Not us, my learned friend. Let's be clear. Us is still to come. You have cited 6 judgments. I will deal with the judgments on file.
At length also, Mr. Banerjee.
well, I was wondering, my lord, if your lordships will kindly, my lord,
You are appearing for?
I'm appearing for respondent number 3, madam.
Yes, please.
No, no,
Please
if I
record. You have
26,
recorded your appearance?
Ma'am.
You have recorded your appearance?
Yes.
my lord, I am, my lord, not going to, my lord, so elaborate with the respondent number 3 because, my lord, ultimately this is a policy of the state. If I can, my lord, succeed in showing that the policy does not meet the standards of law, then, my lord, respondent number 3 is something that I need not really bother about.
He is relying upon our letter.
Respondent number 3 is state.
No, it's the CBW.
CBW, madam.
Beneficiary of the policy, madam.
Ultimately, we may be expected.
No, that's right, but, my lord, this policy is under challenge, not, my lord, the grant of license to the CBW per se.
No license, we are not.
यहाँ रख दे रहा हूँ, सुनिश्चित होता है.
Well, logic, kindly give me that date in March. If I could do it earlier, I would definitely. 27, 28. Ekdam problem ache.
Early March, Mr. Banerjee.
Early March 4th to 7th, my lord. Then we have holidays in Delhi for 12 days, my lord. So, your lordship may make it. I have some other matter. I'll try to. If your lordship keeps it on 18, 19 March, it's possible. Also.
Hello, I am, my lord, of course, very keen to, my lord.
The following week you are not available.
Following week, we mean that
24th onwards,
24th March.
February onwards.
No, my lord, I'm in difficulty, my lord. If I wasn't, I would definitely have come. 2 days, 3 days we'll need.
My lord, we are, of course, very keen, my lord.
Then we can do this. If, say, Mr. Shah takes 2 more days, we will permit you, Mr. Banerjee, to
I would like to attend, my lord, if your lordship kindly gives.
be online.
No, I'd like to attend, my lord. That your lordship kindly.
May I, my lord, request your lordship to kindly allow me to, my lord, conclude my submissions. My lord, Mr. Banerjee and his, my lord, string of juniors can, my lord, of
Your
course.
lordship gives 1 day only, then, my lord, 18th, whatever, 1 day. And we can
18th
agree,
March.
one day your lordship gives, my learned friend wants it earlier, I don't know.
No, my lord wants to, my lord, hear me in February.
Well,
But I am, my lord, very
Because
keen.
Mr. Shah will take, he said 1 hour.
Yes, I but one day or one session, my lord, whatever.
Yes.
My lord, would your lordship, I don't know, it will deviate from my lord's program. If your lordship keeps it on the 27th of February, my lord. But I'll take, don't worry. He will continue and then I'll take that. No problem.
Then I need not say anything.
No, after that.
He was pretty.
17.
Could it be 26th? 26th?
Day. I'm actually, I talk to miss. 27th and I will become.
26th?
25th?
25th is.
No, 25th. Then you can try to come. 25th February, if your lordship gives it for 1 day.
No difficulty.
Not on that day. I
25.
will be out of station. I'll be in Delhi.
You be online, please, because let this be, you be online, we will permit you, but let this be concluded.
I'm leaving for Delhi on the 25th.
At what time?
I'm leaving in the morning, my lord. So he's around 10:45 to be exact.
My lord, we can, my lord, in fact, my lord, if your lordship, since your lordships have heard us, my lord, I don't mind, my lord, coming back, my lord, just for a day next week to finish it off sometime also. Your lordship, my lord, please to, my lord, give me some time, my lord, on the 19th. If it's possible, I can just take one
Second
and
week
finish.
of March.
19th February. You want to come on 19th, is it?
আমি যে একদিন এসে শেষ করে দিতাম, কারণ আমারটা শেষ হয়ে গেলে।
Thereafter, your lordship fixes, my lord.
Yes.
Lordship, just give me one moment, my lord. One moment. 17th, 18th, 19th. Can you make it 20th instead of 19th? Possible.
20th এখন একটু অসুবিধা আছে, একটা খুব contested arbitration।
18th, 19th, আমি তো 18th you want to keep it, is it?
না ঠিক আছে, I'm not saying that if it's convenient for you to do it on any other day.
20th হলে
20 you were saying
first
27th বলছিলে তো তুমি?
27th বলছিলাম।
তো আমি বলছিলাম 26th এ তাহলে করে দিন আমি।
21st is a holiday here to be declared because of some election.
In Gangtok, when will come back?
22nd can't be.
You didn't have to do it.
But then, my lord, may I come on the 25th, as Mr. Banerjee was suggesting? 25th. Come and try and finish it off.
24th hour, no?
24th.
Very well, your lordship keeps it on 25th,
Well, let me finish.
and then
I'll try to come.
we can, if I'm not there, only we can take another date or something, my lord.
Well, let me finish my
You
argument.
are on 25th. You will be.
I'm not sure, my lord, I'm saying, but my learned friend has no other date.
27th, আমি কি পারবো না।
I didn't put on, then I can come.
Just let me see. Well, I don't want to put you to inconvenience. 27th, 28th, আমি পাচ্ছি না।
20th or something.
27th, 28th পাচ্ছি না আমি।
What about 6th March?
20th আমি পারবো না।
6th March? 6th March, it's not too far. You have just, lordship gives me.
Could we then, my lord, do it on the?
Then, Mr. Banerjee, between now, today is 11th February.
I just
And 6th March, it doesn't make a difference because 6th March also our memory will go as much
Yes.
as it will go on 27th March. So 27th March, please keep 3 consecutive dates
Very
and
good.
please don't keep any other engagement.
Very good. 27th, 28th, and your lordship keeps it on the 1st of April. 3 days.
না ঠিক আছে করে দাও। Lord, and I would request your lordship to kindly allow me to finish my arguments so that, my lord, I can at least put in a notes so that Mr. Banerjee can respond and finish it off. Because otherwise, my lord,
Let him give the note. I'll read the note.
No, provided Mr. Banerjee is here. There is no problem.
27th, 28th, and 1st April, man, will give the note. We'll take one session. I'll complete in the next
3 days it will be over.
Well, 25th, my lord, in that case, if my Mr. Banerjee accommodates me, because I'm also finding a little difficulty with my dates. So it's 26th is Kim Ashtu, too.
I have to get that. This is a holiday. 20th, I have to reach that place night. Oh. I don't think the flight will go on.
ठीक है 27th को ले दो तो we'll do it on the 27th.
Yeah.
Well, then, my lord, may I?
Monday is a holiday.
He's saying it doesn't make any difference to him. Cheating for better recap. We both could have recap for us.
25th, 26th, 27th March.
27th, my lord. 27, 28, first lordship gives it.
My lord, really, your lordship, my
No,
lord,
no,
kindly-
first this 31st March is a holiday.
31st March. Oh,
Monday is a long weekend.
Your lordship will, my lord, not, my lord, hear me out and my lord, let me finish my submission sometime in February. 27th February suits my learned friend.
no, 20th February suits, but you can't come on 20th.
No, 27th to me, बोले तो
I'll have to reach now if I get out of Gangtok on 26th. This is connectivity.
20th February করতে চাও?
28th.
28th February. 28th February আমি করতে পারবো।
Reliance in Patel. 26.
Well, very well. We'll come back on the 28th February, my lord. It will be
28th
very difficult, very difficult for me.
I'm
but
very
I-
grateful to my lord. One day your lordship is on 28th February.
February পারবো না জানো। মুশকিল হয়ে যাবে।
27th not possible.
Difficult, my lord. I'll not be able to come personally. That's I want to come personally, if possible.
Well, let us do this then, my lord. Let us.
28th, my learned friend has noted.
Well, let us try to do this then, my lord. What I'll do is, my lord, subject to your lordship, because, my lord, we are really interested in this matter getting concluded. My lord, what I can do is, my lord, if your lordship will, my lord, fix, my lord, 2 or 3 dates, my lord, in March. But I will, my lord, finish in one day. My lord, that is my assurance to
Yes,
your lordship.
consecutive days.
And, my lord, then Mr. Banerjee can start straight.
28th or 27th March will not make a difference because it's almost 1 month. So Mr. Banerjee, we were 3 dates there and Mr. Shah will be there in March, he said.
27 and 28, your lordship.
March.
কি লাভ হবে তোমার ও তো স্পিল ওভার করেই যাবে otherwise we'll have a captured argument with you. In that case, my lord, so since your lordships are keeping, my lord, dates, my lord, consecutive dates in March, I leave it to your lordship's convenience, my lord. We will the 26th, 27th, 28th March, my lord.
27 and 28, your lordship gives.
26th you are not here.
No.
My lord, 26th also, my lord, kindly, my lord, give me, but because Mr. Banerjee will have at least 2 days to
And your
respond.
lordship keeps 26. I shall try to come.
Yes.
I shall try to come. Only one accommodation. I know it's maybe a little unreasonable. If I'm in difficulty, if I could request your lordship to take the matter at 2 o'clock instead of in the morning, if possible. The lordship can do that. Then I will definitely come on that.
Because, my lord, if I finish in one session, then Mr. Banerjee will have 2 full sessions to respond. I was just looking at that.
Your lordship keeps it on the, what day did you say? 26,
26, 27, 28.
26, 27, 28 March. On 26, your lordship, I may take your lordship liberty to
Alright.
come in the mornings.
Mr. Jishnu Shah, learned senior advocate, continues his submissions, but does not conclude the same. Learned senior advocate appearing for the appellant in so-and-so appeal. List these appeals for further argument. As the only hearing matter in the list, after short admission matters, on 26th, 27th, and 28th March 2025.
My lord, I may ask for that indulgence at 2 p.m., my lord, if it's required.
Yes.
Because then on 26th, if required, otherwise.
you ask your advocate of record to talk to the listing registrar.
I am, and I'll tell Mr. Shah in
So
advance.
it will be notified in advance.
I'm obliged. Grateful.